I don't want to take up too much time of our speakers' time, so I will start immediately with the session, and we will let more people joining in the meantime. Today's webinar, as you already have seen from the title, will focus on judicial data, AI and the use of judicial decisions. As you already know, digital transformation is playing a significant role, not only on our day-to-day life, but in different also areas, such as the legal landscape, and especially when it comes to terms of judicial transparency. So this transformation is very much aligned as well with the EU's broader goals of improving the functioning of public administrations, as well as ensuring that digital technologies benefit our society at large. On this aspect, open to judicial data plays a crucial role in achieving this transformation. It enables also better access to information, to the judicial decisions, and generally fostering a greater public trust in the judicial system. I will not deep dive into more about this aspect. I will let our speakers provide us more information. Just for your information, the purpose of this webinar is to provide you with a better understanding of how the judicial systems are being reshaped, and we will also share with you best practices for licensing and reusing judicial decisions in Europe, along with legal obligations for publishing judgments online. We're very much looking forward for the presentations of our two expert speakers, but before introducing them to you, we will just share with you a few housekeeping notes. As you already know, this session is being recorded. Both the recording and the slides will be shared with you and made available on data.europa Academy. We will also include them on the RICA mail that we will share with you a few days after the event closes. At the end of the webinar, we will kindly ask you to complete a short feedback form. And you already know that your feedback is so valuable to us, because then we can further tailor-made our content to your needs. And lastly, as you're already been doing, please use the chat function to post any questions you may have for our speakers. You can also specify on your question to which speaker your question is referring to, and we will make sure to address them during the Q&A session at the end. And if we don't have enough time, we will share the answers on the recap mail. So when it comes to the agenda, we already started with this short introduction. Then our two speakers that I will introduce you in a minute, Elena and Malcolm, will each have 20 minutes to give us more information. Elena will focus on the open judicial data for justice, transparency, and accessibility. And then Malcolm will share best practices for licensing and reusing judicial decisions in Europe. And we'll end up every time with a Q&A. Moving onwards in the introduction of our speakers, we have Elena Yurkina with us. Elena is a legal and policy expert specializing in digital transformation and human rights. She serves as the head of the unit for innovative solutions for human rights and justice at the Council of Europe. And in this role, she leads teams implementing cooperation projects with national authorities, focusing on justice sector reforms, testing and integrating innovative technologies to enhance access to justice, promote human rights, and improve the efficiency of legal systems across Europe. Welcome, Elena. We also have Malcolm Langford with us. Malcolm is a professor of public law at the University of Oslo, a lawyer and social scientist. His publications span international law, comparative constitutionalism, governance of new technologies, and legal education. He is an associate fellow at the Integrated Center on Excellence on Knowledge-Informed Machine Learning, and co-editor of the Cambridge University Press book series, Globalization and Human Rights, and the Oxford Handbook on Economic and Social Rights. Malcolm has also won several prizes for his work on international adjudication, law, data science, and education. Welcome to both of you. We are very happy to have you here. We're very happy to also learn about this topic. And without further ado, I will give the floor to Elena.
Thank you very much, Flora. Good morning, everyone. I'm really happy to be with you and to share with you some experiences and information we had during the implementation of one of our projects, which was dedicated to open judicial justice, transparency, and accessibility. To start with, I would like to provide just a brief information about the Council of Europe to provide some context. So the Council of Europe is an international intergovernmental organization, comprises 46 member states, and it has 700 million Europeans based in Strasbourg, and it is a political organization founded on three main core values: human rights, democracy, and the rule of law. So everything we are doing, it is based on these values. We have institutions and bodies, and you can see them on the slide. The main are the Secretary General, who is, if you compare to private world companies, this is kind of CEO. We have the Committee of Ministers, this is kind of the Board of Directors, and Parliament Assembly, kind of shareholders. We also have European Court of Human Rights amongst the institutions of the Council of Europe, which is a unique judicial organization which examines the application of individuals on human rights violations against individual states. And the European Court is quite unique and important in formulation of the case law on human rights. Then you can see on the slide the main areas of our work. They're quite diverse. We're dealing with absolutely different topics, and efficiency of justice, open data, artificial intelligence are those amongst those. Then how we work. This is quite important to understand what we are doing as a cooperation. So first of all, we have a standard setting angle of the organization where the organization develops and adopts several international conventions. Nowadays, we have more than 200 different conventions. The latest, for example, just to illustrate, were the Framework Convention on Artificial Intelligence, and the Convention on the Independence of Lawyers, and some others. European Convention on Human Rights is amongst those 200, more than 200 conventions. Then we have monitoring bodies who examine how the conventions, the standards are implemented by national authorities, and prepares monitoring reports, identifying the gaps in the implementation of the standards. And finally, we have technical cooperation angle. This is where we're working, and we're trying to bridge the gaps identified during the monitoring and help the national authorities to improve the implementation of the standards. This project, which I'm going to tell about, this is called Tijeni project, was one amongst the cooperation projects, technical cooperation projects we are implementing. The full title is Foster Transparency of Judicial Decisions and Enhancing the National Implementation of the European Convention. And in the project, we were focusing on the transparency of judicial decisions and their publication and national implementation of the European Convention and jurisprudence of the European Court. So looking at the transparency, we looked at the publication of judicial decisions, and there we had four main angles from which we were looking at this question. First of all, personal data protection. You can imagine that in publication of judicial decisions, some personal data can be published online. Then we were examining the topics related to anonymization, or rather, it's better to say pseudonymization of the text of judicial decisions. Then we were looking at the categorization of judicial decisions in the databases, and finally, the summarization mostly before the publication. And I will speak in detail about these four elements. So first of all, the publication. Here, we started with discussing with national authorities we were working with, who were partners to the project, and experts, some quite important questions which were important to understand the scope of our work and how it is organized. So we were asking who is in charge of publication of judicial decisions. We saw the trend that there are more and more judicial decisions are being published online. And speaking about publication of judicial decisions, of course, I'm speaking about online publication of judicial decisions. So who is in charge of publication of judicial decisions? Here there is quite a variety of stakeholders and actors. In some countries, there's courts, individual courts who take the decisions, they publish them immediately on their web pages. In some countries, this is centralized through Supreme Courts, for instance. In some countries, there's a Ministry of Justice who are in charge of collecting all the decisions adopted by national courts and publishing them on the national databases. In some countries, we also saw examples where judicial decisions are collected and published by private publishers. What to publish, this was a very, very big question. I will speak about this on my next slide. How to publish, how often to publish, monthly, weekly, as soon as a decision is taken, how to update, how often to update the databases, what to do if the original judicial decision was updated by the court following the publication. And of course, the risk, the major risk we saw was, as I mentioned already, in personal data protection. Speaking about what to publish, again, a lot of questions we had here, and did some comparative analysis of different practices in different countries. The questions were like, which instance decisions shall be published, whether online, whether only the third instance final decisions shall be published, or first or second decisions also shall be published, whether in a case all the decisions taken by courts in a case shall be published, or only the final one, what types of cases, civil, criminal, administrative, labor, family, whether family shall be published at all, whether there is a decision to publish all the decisions or just those which bring some development in the established case law, and if the decision is published, if not, or just selected decisions are published, who shall take a decision to select the decision or the judgment for the publication. Then answering these questions, we try to see what exists on the level of the Council of Europe, and we found quite some number of documents with recommendations, which could be quite useful for the setting up of online publication of decisions in country. The latest one, which are still relevant and have some nice, good guidance, is as old as more than 40 years old, as you can see on the slide. Then after answering all these questions, just understanding how different are the approaches in different countries, we proceeded with some questions related to personal data. Here we looked at the case law of the European Court. What are the developments there? What are the standards formulated in the jurisprudence? Here, just to illustrate, this is not all the cases that exist at the court. There are quite many of them, but this is just an illustration of some which are relevant to the topic of the publication of judicial decisions online. For example, in the Hungarian case, the national tax authorities were publishing information about the address and also the name and also the home address of major tax defaulters. That was set in the national legislation. So there was an application brought to the European Court, and the European Court was examining the question whether this legislation which allowed this publication or even prescribed this publication, whether this legislation was in line with the standards, the human rights standards in the European Convention. Then another case, a Spanish case, where an applicant who was a teacher was accused of harassment at work. Then the case regarding not him, but against the institution where he was working, both him and the victim were working. The case against that institution was brought by the victim of the harassment to the national courts, seeking compensation for the failure to prevent the harassment. However, this applicant, he never knew about this case, and he was never a party to this case. But he found out about this case from a newspaper publication, where his name was disclosed because his name was mentioned in the decision of a national court. So here the question, and so he had no means to come to the courts to ask to delete his name. And the question was whether this practice was in line with the convention. And the final illustration of such kind of cases is a quite recent Armenian case concerning two type of cases, civil case and criminal case. There was a criminal case concerning sexual abuse, and of course, all the information about the victim of sexual abuse was anonymized in the published judicial decisions. There was no data. However, in the civil case, which the victim brought concerning the damages for sexual abuse, the name of the victim was disclosed together with the number of this criminal case. So these two cases were, it was possible for anybody to link these two cases and discover the name of the victim of the sexual abuse. And again, at the European Court level, the situation was examined from the point of view of human rights protection. So we we combined all this information we discovered on the topic together with the jurisprudence of the European Court, but also jurisprudence of Luxembourg Court, and we developed online course mainly designed for judges, but also for anybody who is interested in the topic. And the course was dedicated to personal data protection, specifically in publication of judicial decisions. The course is available on HELP platform of the Council of Europe. HELP stands for the abbreviation of Human Rights Education for Legal Professionals. And this is a program which provides a platform with many different courses, online courses on human rights topics. They are free and anybody can take the course. You can see we translated also in quite many languages. And this course is quite short. It normally takes only 2 hours. Then we'll also, so we saw that there are definitely some risks in personal data protection. So we wanted also to see what are the methodologies used by national authorities for anonymization or pseudonymization. We did some tests. Here, first of all, we started with the questions, what shall be anonymized? Because, of course, the problem in anonymization, or as I mentioned, rather pseudonymization of text, that at some point it's very hard to understand the judicial text if all the information is taken out of it. So there shall be always balance between personal data protection and deletion of the names, information, but also to keep it to the extent possible so that the users can understand what is in the judgment. Otherwise, the publication of judicial decision has no sense. So, of course, the first names, last names, addresses, ID numbers probably shall be anonymized in all kind of text. Then the more difficult questions like if it is a case regarding a legal company, for example, which has in its title the name of an individual, like Smith and Company or something like this, where the case concerning this company, the name of the company shall also be anonymized. Then the special categories of data and the most difficult question, what is regarding the participants of the proceedings, like for instance, defendant, witnesses, information about judges, whether this shall be deleted from the judgments, names of the lawyers, expert witnesses, third parties, and so on. So again, there is no consensus. There are different approaches in different countries. For instance, in civil law countries, there is a tendency to anonymize a lot of information. In common law countries, the judgments are normally published with all the information except for the family cases and some criminal cases. Then we looked at the categorization. Why? Because if all kind of judgments and decisions of courts are published without proper categorization, this makes no sense in publication because it's just not possible to process all the data to find necessary needed information and specifically to analyze information. This is why we were focusing on categorization as quite an important element which accompany the publication of judicial decisions online. Here we prepared a couple of reports trying to understand what are the possibilities of semantic categorization, what types of categorization exist in different legal databases, and we also looked at the experience on French Court of Cassation, where they do the categorization or indexing tagging of judicial decisions, different judicial decisions, which allows to identify similar judicial decisions and check the discrepancy in the jurisprudence, which is a very important question. So for this, we try to understand what technological decision solutions could be used for the automated categorization of the text. For this, we organized a hackathon where we brought different teams from different countries. We had 6 different teams participating, and we had jury members and mentors for the teams from the judiciaries and data scientists. And we wanted the task, the challenge we proposed to the teams was to try to develop solution, IT solution that would analyze the text at hand and propose different categories. And for the categories, we provide keywords. And for keywords, we provided the keywords of the used by the European Court of Human Rights. There are approximately 300 words which we proposed to see. We saw it as also a potentially very practical solution, which is developed, could be used by judges, where they could analyze the existing text or the text that they're drafting from the point of view of possible potential human rights issues, which could be brought to their attention during the drafting period if they use the application that proposes human rights keywords or categories. So that hackathon was quite successful and brought us a lot of food for thought and ideas for further developments. And final element is summarization. Why? Because in many countries we know that judicial decisions are published first of all with summaries. Secondly, again, it is very helpful to have a summary of the text if for the research purposes, for example, because it's really hard, even if you're doing research, you find 10 judgments, it's really hard to go through all of them. So summarization is a great tool helping the research. So summarization can be used for this purpose. It can also sometimes used to summarize the documents in a case file that are prepared for the examination of a judge to speed up the process of the revision of preparation of the judgment. And finally, it can be used also to for the analysis of the jurisprudence, which we saw in the example of French Court de Cassation. So summarization, as we saw, can be in two different forms. It can be extractive, and here the risks are in the loss of logical chain between elements of reasoning. And extractive is mainly used by technological tools on the basis of artificial intelligence. And summarization can be abstractive. And in this case, the risks are misinterpretation in the reasoning or replacement of existing legal terms by synonyms. So we decided during the project to test existing then publicly available AI tool, which just appeared on the market, trying to see how it can be used to summarize judicial decisions. For this, we developed methodology which which was as you can see on the screen. First of all, we splitted the text of a judgment, and for the testing, we took judgments of the European Court of Human Rights, which are openly available on the database of the European Court, the HUDEC platform. So we took several selected judgments, we splitted them in the parts, topics, facts, law, conclusions, and remedies. And we made the assessments from two angles, correctness and completeness. And we scored from 0 to 2, three-step score of the results. Then we proposed this, we had organized an event where we brought judges from different countries and proposed them two types of summary. One prepared summary of the judicial text, one prepared by the lawyers of the Registry of the European Court, the summary which is normally published together with the judgment of the European Court. And secondly, we propose them, the second document, we propose them summary prepared by artificial intelligence, with the use of artificial intelligence, with the support. And of course, they didn't know which text was prepared by humans, which text was prepared by with the use of artificial intelligence. And we asked them to score the results, a two-text comparison of two texts. You can see on the slide the results. So you can see that in many parameters, in many cases, the summary prepared with the use of artificial intelligence got better scores, except for the description of the facts and clearness of the conclusions. Then we did the same text with Greek test with Greek text. Why? Because we wanted to see whether we can introduce some methodology to use artificial intelligence in summarization of judicial decisions published in Cyprus. So these are results of the Greek language test, and you can see that artificial intelligence use support is much worse, and it almost didn't work, unfortunately, because we reversed the sequence of the document. So here we first gave the AI-based prepared text, and secondly the original one. So that allowed us to make some conclusions regarding the summarization, which we put in our methodology as conclusions. First of all, that automated summarization has a great potential. However, the results shall always be verified by legal professionals who know the facts and substance. There are limitations for non-Latin languages, and there are, of course, risks of commercial tools for human rights because of the lack of transparency and potential biases. So asking about how to address possible risks, again, we looked at the instruments existing at the level of the Council of Europe. One of the latest recommendations, which we found quite relevant and useful, is on human rights impact of algorithmic systems, which has quite a number of recommendations. Finally, the overall conclusions for the use of any kind of technological solutions for online publication of judicial decisions, that first of all, the human rights, fundamental rights, and the rule of law shall always be kept in mind. There are some instruments that can provide some guidance or recommendations which exist on the level of the Council of Europe, which can be checked. And in any case, national authorities shall always introduce effective remedies in case anything goes wrong and with personal data, and it quite often something can go wrong. You saw in the cases of the European Court, which I mentioned before. So I will wrap up here. There is some reports, information about some reports we prepared during the project. And with this, that's it. That's all information I wanted to share with you. Thank you very much for the attention.
Thank you very much, Elena. We have already received questions. We will address them at the end of the session. Malcolm, now the floor is yours.
Thanks very much, Flora. Thanks, Elena. And it's wonderful to be with you all today. Open justice data. Let's start with a puzzle. When we look across Europe, we find, as we will see, very few national judgments published online and made available with APIs, besides judgments at the Supreme Court and Constitutional Court levels. And this is a puzzle because, firstly, if we read the European Court of Human Rights judgments, access to judgments is important for democratic debates because courts often raise important public issues. Judiciaries also need to be accountable, so it's important we see what they write. And it's also important for the rule of law that we have, for example, consistency and correctness, and that we can see what is happening in courts across the continent. Secondly, legal researchers need access to judgments, and not just the judgments of the highest courts. Obviously, these have greater precedential and authoritative value. But in most areas of law, most of the judgments never reach a court of appeal or a Supreme Court. The only relevant legal source is, in fact, at courts of first instance or different tribunals on different topics. Thirdly, there's a great demand for judgments in online forms that are readily accessible. With machine learning approaches, data is gold, and volume is also gold. And therefore, having access to all judgments is very important in developing new legal technology services. And I can see already in the chat some examples that have been given. And this is both for courts, but also lawyers, and also citizens and others who wish to take claims. And we're seeing an explosion now of legal technology services, for example, in courts, to make processes more effective, to provide management analytics, for example, on issues of efficiency, but also bias in decision making. We're seeing tools for summarization, as Elena has also just presented, but also some work on semi-automation of particularly simple or cases which have low values of compensation claimed. Some of these types of cases obviously raises issues under the AI Act, Annex 3, as high-risk systems. But many of these approaches, regardless of their ambition, need data. And lastly, it's a puzzle, given digitalization expectations. Most countries now have a digitalization strategy in which public sector institutions are expected to publish as many documents online as they can. There are both UN and European-wide rankings of countries according to e-governance. And for example, the Minister of Digitalization in my home country now in Norway wants Norway to lead the world by 2030 in publishing public sector information online. But when we look at the case of judgments, we see very low rates. We've looked at a range of countries across Europe, and these are just absolute figures. And when you look closer at the numbers, and for older people like me, it's a bit difficult without very strong glasses to see the numbers. But for example, if you just look at the United Kingdom, which is actually one of the better performers, you're only up to around 25,000 judgments each year at first instance, much lower for second instance, and even lower for the supreme instance, but where, of course, there are less decisions. But whether we look at United Kingdom, Estonia, which is one of the better performers, Poland, Malta is also a good performer, actually, or France, Germany, Norway, we see very low absolute totals. And Norway is perhaps a good example. Every year, there's around 210,000 court and tribunal decisions, but only around 3% are actually published online. And even many of those are not available free. They're behind a paywall with legal information companies charging for use to access. The clear exceptions are the European Court of Human Rights and the European Court of Justice, which publish most of those decisions, particularly those at first instance and also appeal. Obviously, there's a question as to which countries are performing best given the numbers of decisions. I would say Malta perhaps falls into the category there. We tried to measure this, but we found it extremely difficult because the quality of the data for all decisions that are actually made is very difficult to locate. We do have the EU Justice Scoreboard through CEPEJ, and there is an annual questionnaire where court administrations send in information. But we found the quality of this data not sufficiently good, like other academics, and therefore we felt we were unable to report it. So hopefully that's something we can fix in the future. But the key point is publication rates are rather low. The question is why? Is it privacy constraints, as some have mentioned, and we've heard about privacy demands, which can make it very difficult or expensive if one wants to de-identify judgments after they have been made. Secondly, is it a lack of legal obligations at the regional and national level that require public administration and court authorities to publish judgments? Thirdly, is it because we have so many private monopolies on legal information provision that fight against greater access? Or is it just a lack of political will or interest or conservatism in the legal profession? If we look at the privacy issue, in the cleanup project financed by the Norwegian Research Council, we looked at how easy it was to automatically de-identify and anonymize decisions in a series of machine learning papers, but also legal papers. To what extent, for example, can anonymous automation fulfill GDPR requirements? And this research shows that, in fact, it is possible to develop techniques to automatically de-identify judgments for privacy, for personal information. And we've seen work on this in Croatia, in Austria. But as we'll see, there's also even perhaps simpler techniques like we see now in England and Wales, where de-identification happens actually when the judgment is written rather than afterwards. So our research indicates that it is possible to have de-identified judgments at scale. So let's look a little bit more at what's happening in practice. And we have a new paper on open justice data in Europe, and also a report for the Council of Europe on the licensing conditions to protect against some of the risks like privacy, but also artificial intelligence misuse, which I will come to. So we had 5 questions. Is there a duty to publish? What are the practices of publishing? Is there a duty to anonymize or de-identify? What are the methods? And how is online publication regulated? We looked at 12 European countries, as well as the European Court of Human Rights and European Court of Justice, using both doctrinal methods and descriptive statistics. So is there a duty to publish? Looking at the European Convention on Human Rights and looking at the EU Charter on Fundamental Rights, there's clear that there is an obligation to make judgments available. But it's difficult to argue that right now in Europe, there is a duty to make the judgments available online. It's arguably a superior way to fulfill these obligations, and there is a potential for the jurisprudence to change over time. But right now, there's not a clear regional obligation. However, when we go to the national level, we find great variation. If we look at the top courts, Supreme Courts and constitutional courts in particular, we find that in some countries, Croatia, Czech Republic, France, Italy, European Court of Human Rights, Estonia, there are clear duties to publish online. In some other courts like the constitutional courts in Czech Republic and Italy, it's just to publish in any medium, not specifically online. If we look at lower courts, we also have some countries, but less, with these sorts of duties. Other states have a more limited duty, for example, to publish the decisions just of the highest courts, or on decisions of great interest. We also have one country where all decisions concerning corruption had to be published online. And then we have an array of countries where there's no duty and it's just mere policy. So what happens in practice? I've already showed you the statistics of many countries, which shows generally low online publication rates, but also variation between countries, with some publishing more. And we also see a new trend or an acceleration of publications in, for example, France and England and Wales. What is then interesting to see is, does law matter? And we compared, for example, countries which have a strong duty to publish with countries that have a strong practice of actually doing it. And those we call the compliers. Then we have the poor compliers, where there's a strong duty and weak practice. Those who are proactive, where there's a weak duty but a strong practice. And then we have the reactive publishers, where there's a weak duty and weak practice. And we classified the states in this way. And you can see that some states match the duty and the practice, where others, where there's a weak duty, like Malta and England and Wales, actually have a strong practice despite the weakness of obligations. So law doesn't necessarily explain everything here. It's only one part of the picture. And I think in that respect, England and Wales is perhaps most interesting, because after a 2019 judgment, which found that judgments are a public record and need to be handled properly, the administration developed a new policy seeking to publish all judgments online. But they adopted a very interesting approach to data protection by requiring judges, when they write a judgment, to determine what is protected personal information that must be de-identified. And in some cases, actually, the judgments need to be anonymized in certain cases regarding children. And so the judge makes that determination. They do consult with the lawyers in the case. And so when they write the judgment, it's de-identified or anonymized. And the moment they click the button to decide on the judgment, it's published automatically on the National Archives website. And you can see that website, Find Case Law, where we're seeing an increasing number of judgments appearing. In France, we've also seen a massive move to publish online after a new legislative framework, and also in Croatia. In France, de-identification tends to happen afterwards, whereas it tends to happen in advance with automated methods in Croatia. I'll come back to that. Thirdly, the privacy issue, and I can see there are many questions popping up also in the chat on this. Is there a duty to privatize, to de-identify or even anonymize? The key principles are in Article 5 of the GDPR: fair, lawful, and transparent processing. There are limitations on purposes, and there has to be data minimization. The key article, as we all know, is Article 6. You need a legal basis for the processing of personal data. If there is a duty to publish online judgments, then you usually have that duty. If not, then there are often legal questions over the extent to which existing duties to publish extend to publishing online. And that's often a very fine-grained legal question. We see in the European Court of Human Rights also various privacy requirements for judgments, which are comparable to the GDPR, but it varies according to the context of the case to what extent there has to be protection. And as Eleanor mentioned, we see in civil law countries, they tend to go much further than the common law countries. Poland in particular has very detailed regulations about all the information that needs to be de-identified in a judgment. And we've mapped this also in a second paper, the types of obligations we see at the national level on which information needs to be masked. And Portugal, which I also see in the chat, is also an example of quite detailed regulations there. Example from Ireland, UK and Malta, de-identifying cases involving certain sensitive matters, minors, victims of sexual offences. That's quite common in Europe. Perhaps an ideal situation is, it's up to you, we might have different views, is where you have strong privacy protections and strong publicity requirements, where you get a balancing. But we can also have other scenarios where strong privacy, weak privacy, strong publicity. And we see across Europe, different countries falling into different categories here. And I'm happy to talk about that more in the break. So how do we do de-identification or even anonymization? Essentially, there's three types of methods. You can do it manually. So you can have a court assistant, a judge's assistant, a library, an information legal provider, manually going through and doing the masking. For example, for names of people, for places, for even time, depending on the extent of the risks involved and the types of cases which are of concern. Then you have partially automatic methods, which we have in Norway, where you have an automated system to search for all words in a judgment that may directly, or in some cases indirectly, provide personal information with automated suggestions according to the degree of risk one wants to follow. And then you manually decide whether those words will be masked or not. And then you can have a fully automated tool, which we do have infrastructure for now and is being tested out in some countries. In terms of timing, as I mentioned, you can have the British system where you de-identify before the judgment is issued, or you do it after the judgment is issued. And that means we can also think about, again, a 2x2, where we have some courts doing it manually before the judgment, so we can call them conscious courts, or potentially computational courts who do that manually automatically before judgment, or those who do it post-judgment, cleaning up for privacy concerns using humans or computers. And so the last point from me is, what type of conditions are being imposed when data is given? Because there's a clear risk, say, for example, in Norway, if we move from publishing 3,000, 5,000 judgments online to 200,000 judgments every year in the country. And if we look at the European framework, there's obviously different data licenses that can be issued to people or legal information providers or legal tech startups as to the conditions under which they can use that data. If we look at the common licenses, increasingly the most popular one now is the Creative Commons Attribution 4.0 license, which I'd encourage you to look at. And we see it's quite commonly used by courts in Europe. What we did is we did a country review of 6 countries, looking at the license provision, the approval process, the terms and conditions in the license, and the technical conditions. And if we look at these 6 countries, I want to particularly draw your attention to England and Wales. We have perhaps the most developed system for this. So for an individual user using Find My Case Law to download decisions, they effectively agree to a license where they will comply with data privacy requirements, administrative justice requirements, data integrity, so not interfering with the judgment text and then republishing it with altered text, and also certain warranties about harm. If we look at access to data for computational reasons, for example, used by legal tech startups, they also have obligations in relation to responsible AI, and they will not misuse the data to interfere with court processes. And we've seen also some risk around, for example, use of judgments to identify potential clients of banks who may default. These sorts of uses would also be not permissible under such a license. So let me conclude. What we see across Europe is an experimental model with great variation in practices, in laws, and ways of making large volumes of judgment data available. And in my view, it's time to move to a European regulatory framework to get more consistency, to get better access, but also to get better protections, particularly in relation to data privacy and misuse of AI. Thank you very much.
Thank you so much, Malcolm. Thank you so much, Elena. Now I would like to invite you both for our Q&A session. I will turn that to this view. We will try to answer as many questions as we have. I will start with a question that came up one or two times, maybe with a different phrasing, like a question that I was expecting. Malcolm, I will address to you, but please, Elena, feel free to step in. It's related to the open judicial data and the safety, how safe I are. Like, apart from privacy concerns, like, do you see any risks in publishing judicial data? For example, people using past judgments to predict the outcome of current cases. And could this kind of public attention influence judges? And if so, what can be done to prevent it? So it's two questions in one.
Okay, so there are some great questions there. So in terms, there's a basic security infrastructure question. So obviously courts and other bodies will want to keep the original decision. And so that may need to be saved somewhere else. And then what's made available may be de-identified or anonymized according to the local jurisdiction. In relation to potential misuses, there is one European country where banks started using judgment data to identify potential customers who are at risk of defaulting because they've been in a court case involving debt, and then use that to screen clients. So that's very problematic. But what is positive about that case is that they then lost access to judgments. So it's very important that court administrations and regulators follow also how the data is being used. A second way of protecting that is also to have an approval process so that you know who is using the data. And one of the very positive aspects about the system in England and Wales, that is, if you want an API, a computational license, you have to make an application. And then a committee of highly competent lawyers and data scientists look at that. And they'll look, for example, if you want to predict outcomes of judgments, why are you doing that? For some purposes, it might be useful. For example, researchers or courts might want to know if there's something, if bias is occurring against particular groups in the judgments. Lawyers may also want to use it to help clients understand the risk involved in making a decision about whether they want to proceed with the case. But when it's used to interfere with the actual administration of justice, for example, publishing things online or gaming the system, forum shopping and these sorts of things, then it becomes problematic. And we need systems in place to regulate for that.
Thank you, Malcolm. I don't know if, Elena, you want to add something on this?
Yes, thank you very much for it. Just a couple of words. Indeed, the problem here, as we see, it's not in the openness of data, but how it is used. And at the beginning of the project, we were thinking about the risks of users profiling, but there is also existing risks of judges profiling, which is also can lead to the forum shopping, for example, and this is a problem in several countries. In some countries, this is addressed, like for instance, in France, this question is addressed through legislation, regulatory framework, and if I'm not mistaken, there is a criminal liability for profiling of judges. And then indeed, as Malcolm absolutely rightly said, this information and open judicial databases can be used by banks and also by insurance companies for medical cases. This is why these cases sometimes fall under the sensitive data parameters. And the question is how to regulate it. Maybe not all the information shall be public and be published. Then regarding this, as I mentioned, these concerns were also examined by the European Court in the Hungarian case, which I mentioned, because one of the problems was that disclosure of information about personal addresses of the tax non-payers can put them at risk from the point of view of some attacks or something like this. So this is also a disclosure of information, this kind of information can be problematic. And final comment that we saw in one of the jurisdictions when we were discussing this, they introduced the fee payment for downloading of information it was from land register data about the landowners. And this very, very small fee, like a couple of cents, in fact, was blocking from mass data scraping, which possibly might be also a solution for consideration.
Thank you, Elena. In the meantime, I see we are getting more and more questions. As I mentioned before, we'll try the best to answer the majority of them. If not, we will include the answers on our recap mail. Another interesting question that we have received, I will address it to you, Elena, and then Malcolm, if you want to, you can step in. It's if we have a detailed overview of the countries where there are exclusive arrangements that are limiting the use of decisions.
Sorry, Flora, can you reformulate the question? I didn't get.
Do you have a detailed overview of the countries where there are exclusive arrangements limiting the use of decisions?
No, we haven't seen this, but maybe Malcolm during the research, maybe they saw.
Yeah. So two things. One of the slides I jumped over was on the Open Data Directive, which actually regulates the licensing arrangements between courts and legal information providers. And it's important when you make a decision to have these agreements and release the data, then there are provisions around making it freely available or not too costly, about not being discriminatory in who gets access to that data. In the Norwegian context, there is now a question as to whether the agreements between the court administration and 3 providers actually could be in violation of the Open Data Directive. So it's a real issue around these exclusive arrangements and whether the Open Data Directive actually now would find them in contravention. The other question I might just take up is the volume of data, because I saw a question about that in the chat. When it comes to summarizing decisions, you don't necessarily need a huge volume of data from your country on a particular topic. So some of the large language models, ChatGPT, but certainly some of the other ones, which sometimes are even better, are very good at just summarizing a decision as is, because they're very good in multiple languages. If you fine-tune the model with RAGs, then we find it becomes even better at summarizing. So if we have a system now where I can put in, 100 or 1,000 judgments into ChatGPT, and then we ask it to do a task, and it becomes much better, for example, at summarizing Norwegian judgments. However, when it comes to prediction, which some of you ask about, then it's a greater challenge in the smaller European countries and in areas of law where there is less cases. So, for example, in contract law, there's lots of cases, particularly at the lower court level, even at the higher court level, which we can use to train up a model for prediction. But in constitutional law, very few, lesser cases, which means we have to work much more with the models, interpretation, but also using classical AI, rule-based approaches, to embed put representations in the embeddings of the model. The other issue is language, and Elena's example of Greece is a good example of this. These large language models are very good in some languages, but are weaker in others. For example, ChatGPT is very good, much better at Danish than Norwegian, and sometimes mixes up the languages. So it's also important to train these models on your local languages.
Thank you, Malcolm. And it's very nice that you are touching about this aspect and the AI aspect. We also received a question related to the EU AI Act and how the Act might affect the licensing and use of judicial decisions in your own research, for example.
Yeah, so that's a great question, which requires a seminar in itself, because there's both the development and deployment aspects of the AI. There are also privacy requirements in the AI. And there's extent to which under Annex 3, the provision of data as an act of public administration is also linked to the development and deployment of AI systems. So I think it's a complex question that needs to be addressed. We have recently got 160,000 decisions and 4 million documents from the Immigration Directorate to undertake machine learning and qualitative research. The GDPR was most relevant in that process, but we're also looking at the AI Act. And also very quickly on another question that came up, can we detect absurd decisions using AI? We have a recent paper on that using anomaly detection methods, where we look for judgments which are written in a strange way. They're structured differently. The arguments are different. We went through 40,000 decisions in Norway. And what Amelia Falk found was that we found around 100, 200 decisions which we read more closely. Some we understood perhaps there were good reasons why they were written or structured differently. Others were perhaps in the absurd category.
Perfect. And maybe I will have just one last question, one and a half, I will say, for Elena. It's related. Many people were very curious about the methodology that you are following, as well as the tools that you have adopted. For example, they would like to know which tool you have adopted for anonymization and pseudonymization. Even though it's a Greek, coming from a Greek root, I cannot actually say it correctly. And if you are, regarding also the AI tool that you're using, how you choose, why you chose it.
Thank you very much, Flora. This is a very good question. This was amongst one of the first questions we were dealing with under the project, where we brought together the authorities from different countries and asked them what the tools they use, because it's very different in different countries. It depends on the national authorities, the way they decide which tool is used. However, the general trend is that the tools are developed in-house by the courts themselves on the basis of open source. And however, if I remember correctly, in some countries they're bought from the shops. Here, I would like just to bring attention to, for instance, we tested the ChatGPT tool. However, we put in the recommendations that the use of this tool, because of the questions with the transparency and how it works, it can raise some question for human rights. So whenever the tools are not developed from the beginning by the national authorities, but are bought from a shelf, these considerations shall be really at the main. And for this, just brief information, at the Council of Europe, there is a recently adopted framework convention on artificial intelligence, and following this, there is methodology developed by the Council of Europe, which is called CUDERIA. This is a methodology for the assessment of impact of artificial intelligence tools, which could potentially be used by national authorities in assessing the tools, the solutions that are used for including for those for the anonymization and pseudonymization.
Perfect. Thank you so much, Elena. We had much more time to continue this conversation, but we will try the best to answer your questions, the remaining questions, and share them with you in the recap mail. Before closing this session, I would like obviously to thank both of our speakers. But I would also like to remind you to stay up to our 2025 activities. We will have new webinars coming soon. But also, if you want to discuss further on this topic, we can continue the discussion on our collaboration channel, where we will have a dedicated section that you can further discuss on judicial data. I see that my colleague also shared the link, so feel free to join the discussion, and we will be very happy to see your thoughts there. I'm gonna close with the feedback form. I already see that people are filled it in, and I would like to thank once again Elena and Malcolm very much, very much. Thank you for today's session. It was so nice learning from you. And I'm wishing all of you a very nice weekend and hope to see you in another Data Europa Academy webinar. Thank you.
Thank you very much, Flora, and thank you for the participants as well. Have a nice
Thank you very
weekend.
much.
Thank you.